It is June 11th of 2026, and this is the Court Gallery. When you're facing a judge, honesty is usually the best policy. Usually. We start with a man on his last chance in drug court who says his life is much better now, despite 5 new violations. We've seen this guy before. Then, we meet a woman who explains her decision to destroy a police computer by kicking it to death was just a momentary lapse of emotional regulation. And we end with one of the most unique legal arguments you will ever hear. A lawyer defends his client's felony registration charge by explaining the original offense was mooning a prison guard. Is that even illegal? We're going all the way to the moon with this one, kids. Buckle up. It all starts right now.
Matters the State of Michigan versus Timothy Wadesky, file 25-6791-FH-33. You see Mr. Wadesky is present at the Otsego County Jail. Mr. Dick, I believe this is your matter as well.
Yes, Your Honor. James Dick on behalf of Mr. Wadesky.
Mr. Hamlin with us. There he is. I do see Mr. Hamlin from the drug court. Probation is with us as well. I believe we're here on Mr. Hamlin, are we here on the probation violation for drug court?
That's correct, Your Honor. Currently, we have 5 pending violations.
All right, so we have one on March the 12th, one on March 22nd, one on March 26th, March 31st, and then April 10th. Is that correct, Mr. Hamlin?
Yes, Your Honor.
All right. Mr. Wadesky, these are the probation violations that have been alleged against you. That on March 12th, 2026, you were a no-show for a scheduled counseling appointment with Bear River Health. On March 22nd, 2026, you were a no-call, no-show for a scheduled drug screen at Great Lakes Screening and Services. On March 26, 2026, there were a no call for a scheduled drug screen at Great Lakes Screening and Services. On March 31st, 2026, you failed to complete a community service as per your phase requirements and or failed to abide by the work camp contract to assist in paying off fines and costs. And on April 10th, 2026, you were a no call for a scheduled drug screen at the Great Lakes Screening and Services. You understand the allegations that have been made against you?
Yes, Your Honor.
The recommendations are that you've got 7 prior sanctions within the program. And because of that, the sanction is left at the discretion of the court and could include up to dismissal from the program. Do you understand? If you were dismissed from the program, you'd also be subject to resentencing for failure to complete the drug court sobriety court program. Do you understand all of that?
Yes, Your Honor. And I really just would really like to stay in the program. It's helped me and helped my life a lot. I know that I've had some difficulties, but my life now is much better than it was before I got in the program. I know that, at this point in the program that you guys are looking for a return on investment that you guys have made into me, and I'm relatively far in the program, and I had been dealing with like I lost the doctor. I got discharged, and I've been off medication, and I've been dealing with some mental stuff, and I can do this, Your Honor, and I want to do this.
All right, I am going to give you an opportunity to tell me anything that you want me to know, Mr. Wadesky, so don't worry about that. So I hear what you're saying. In a moment, I'm going to address your attorney because there's some procedural issues that we have to work through before we get to what it is that you want to tell me, but I will obviously give you every opportunity to tell me your side of the story. Mr. Dick, how does your client want to proceed today? Does he wish to have a hearing and what would he like to do?
No, Your Honor, I believe that he is just going to acknowledge the violations. Mr. Wadesky, correct me if I'm wrong, but then kind of plead his case, Your Honor.
All right. Mr. Wadesky, just so you have complete knowledge of how things are going to work, if you want to have a hearing, that is, if you want to contest any of these issues, we will grant you a hearing. At that hearing, it would be in front of me as the judge. You do not have the right to have a jury trial on a probation violation. At the hearing, you'd have the right to have your attorney represent you. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence. You could get a subpoena from the court to require those witnesses to appear and testify. At the hearing, you could testify yourself, or you could choose to remain silent, and that silence would not be used against you. At the hearing, you'd be presumed innocent until proven guilty by a preponderance of the evidence, and that burden of proof would remain with the prosecutor at all times. At the hearing, you could also appeal any error at that hearing, and those would be your rights at the hearing. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about those rights?
I guess my question is like, as far as like, let's say the one, you know, missing counseling with Rosario, like I definitely have proof that like she knew I wasn't coming and it was rescheduled, and like I have text messages between her and I. Like, is that something that I need to bring to a hearing, or is that something that I mean, like some of these, you know, like I have proof that like I didn't do, I guess.
That if you want to present a defense, you are entitled to do so. You're entitled to bring that information to my attention and say, Judge, I didn't do that bad thing. If you want to do that, we will schedule a hearing and have that done. That's your right and your privilege, and you'll be allowed to do that. I can't tell you what to do. That's between you and your attorney to decide, but you have the right to do all of that. On the other hand, if you wish to admit, you can do that too. So that's your decision and yours alone to make. So do you want some time to discuss that with your attorney in a breakout room today? Or what would you like to do?
I would like the opportunity for a breakout room, sir. Thank you.
All right. We'll put you in a breakout room, let you discuss those things with Mr. Dick. We'll take some other cases while you're doing that. And when you come back, we'll hear what you have to say.
Yes, sir. Thank you.
You're welcome. Court will recall the matter of the state of Michigan versus Timothy Wadesky, file 25-6791-FH-33. Mr. Dick, you've had sufficient time now to speak with your client about how he wants to proceed.
Yes, Your Honor. At this time, I guess we will request to set it for a hearing.
All right. Find me a date. Mr. Hamlin, do you have any times when it would be, what do you suggest, how long you need to get that done?
Your Honor, I don't see it's taking more than like 30 minutes, an hour max.
All right. When do we have time available to do that? We don't need to do it on a drug court day. Any day is fine.
I guess how long,
30 minutes, 45
well,
minutes.
how far out do we need to prepare?
Mr. Hamlin, you need more than a week or two?
Your Honor, I might defer that to the prosecutor if there's going to be witnesses or discrepancies in the reports.
Mr. Fortier, do you want a couple of weeks to prepare?
I think that would be fine, Judge. Shouldn't take that long.
July 2nd, Thursday, July 2nd at 3 p.m. Any conflicts with that date?
No.
No, Your Honor.
All right, I'll see everybody on that date. Thank you very much.
Thank you.
Thank you.
Your Honor, do you need to see anyone else today?
Yeah, we had Kelly Poplin.
Okay, thank you.
Thank you. All right, I do see that Ms. Poplin is present from the jail, so I'll call that case State of Michigan versus Kelly Poplin, file 26-44436-ST. Are you in fact Kelly Poplin?
Yes,
All right. Ms. Poplin, you're here on a bench warrant arraignment. It looks like the warrant was issued for your failure to appear for a show cause on May the 8th, 2026 on an underlying charge of driving without a valid license. Do you understand the bench warrant, reason for the bench warrant?
yes, I do.
A bench warrant is enforceable by contempt of court, typically on a first offense, limited to 30 days in jail and or a $7,500 fine. You understand the maximum possible penalty that could be used on the bench warrant?
Yes,
All right. As to the bench warrant, you have the right to have a hearing on that. You have the right to be represented by an attorney. You cannot afford one. An attorney would be given to you. You'd have at the hearing, you'd have the right to see, hear, and question witnesses. You can present your own witnesses and get a subpoena from the court to require your witnesses to appear and testify. At a hearing, you could testify or you could remain silent, and that silence would not be used against you. At the hearing, the burden of proof by a preponderance of the evidence would be on the probation department or the prosecution, and you would have the right to appeal if there was any error at that hearing. You understand the rights that I've just given to you?
yes, I do.
Do you have any questions about any of those rights?
No, I don't.
You wish to have an attorney on this matter?
I do.
Doesn't look like an attorney has yet been appointed on the underlying case either. Mr. Brown, if I put you in a breakout room with Ms. Poplin, would you be able to assess whether or not she qualifies for court-appointed attorney?
She does qualify, Your Honor. I spoke with her yesterday, so she
Okay.
would qualify for an attorney, and she did request one.
All right, thank you very much. I will appoint an attorney for you then. What I'm going to do is also arraign you on the underlying charge because it doesn't look to me like you've had that done to or for you yet. The criminal charge made against you reads as follows. It says that on or about March 14th of 2026 in the city of Gaylord and Otsego County, that you did commit the offense of operating with no license or a multiple license, in that you did drive a motor vehicle upon West Main Street, a highway in the state, without a valid operator's license or a valid chauffeur's license and the appropriate endorsement for that type of vehicle. And that's contrary to the Michigan compiled laws. That's a misdemeanor offense, has a maximum penalty of 90 days and or a $100 fine. You understand the charge that's been made against you?
Yes, I do, sir.
You understand the maximum penalty for that offense?
I do.
Similar to the rights that you have on a bench warrant, you have the following rights as well. You have the right to plead guilty, not guilty, or stand mute. You have the right to have an attorney represent you, and we will appoint an attorney for you on this charge. You have the right to see, hear, and question all the witnesses against you. You have the right to have a trial in front of a judge or a jury. You have the right to have a subpoena to require witnesses to appear and testify on your behalf. You have the right to present your own witnesses and evidence. You have the right to testify yourself or to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof remain with the prosecutor at all times. And finally, you have the right to automatically appeal. Do you understand all of those rights?
Yes, I do.
Do you have any questions about any of those rights?
No, I don't, sir.
All right. I'm going to enter a not guilty plea on your behalf to give you an opportunity to meet with your attorney that's going to be representing you, and you can decide what to do after you've spoken with your attorney about that. I do note for the jail's purposes, the court still has not received fingerprints. So if you could make sure that she's been properly fingerprinted, we would appreciate that. Mr. Brown, is there anything else that we need to do today on behalf of Ms. Poplin?
Just to consider bond, Your Honor.
Thank you very much. I appreciate that. Mr. Fortier, on this matter, any issues as from your perspective as to bond? Any comments that you wish to make?
Your Honor, I guess I would just suggest that, you know, naturally with the show cause, that the failure to appear at the show cause or at the arraignment leading to the show cause, then the failure to appear at the show cause hearing leading to the bench warrant, if we can just make sure we have updated information in the court file, I guess, for her, so that she gets notices and she'll appear at future court dates. I mean, it's a non-serious misdemeanor, so I wouldn't have any issues with a PR bond as long as we have, you know, the court is provided with accurate information so that she receives notices for her future court hearings.
Thank you. Mr. Brown, any comments that you have as to bond?
Your Honor, I would agree with that recommendation. Ms. Poplin is 42 years old. She does have a young child, which apparently she took that child to a stepdad's house or a dad's house in North Carolina because she is currently homeless. So that may be an issue. I don't know if her employer would accept, because she is working, would accept notice or how she could get it. But that is going to be an issue. And again, this is a non-serious low-level misdemeanor. So I don't want her to just rack up different violations because she's not getting notice of failing to appear.
Ms. Poplin, you have the right to address me as to the issues of bond. How do we make sure that you show up for court next time?
This was the first time I've ever done this, sir. It was an accident. Sorry, I'm crying. I just started back at my job at Lucky's. They wanted me to work there because I'm good at my job. I'm trying to get into a hotel room. I mean, it was an accident, Your Honor. I didn't mean to miss it. I had a lot of things going on.
Okay, so how do we get a hold of you?
My phone will be turned back on soon. And you can actually send the mail at 414 Trillium Trail.
Who lives there?
An old roommate.
That's here, Trillium Trail, that's here in Gaylord, right?
Yes, sir.
So if we send notices to that address, they'll get a hold of you?
Yes.
All right, do I have your word that you show up when you're supposed to show up, every time you're supposed to show up?
Correct. Yes, do.
All right. I'm going to set a $1,000 PR bond. That means that you do not have to post any money up front. However, if you fail to appear in the future, you would then owe the court $1,000. Do you understand that?
Correct, sir.
And most likely what would happen is we would find you and pick you up and put you right back into the jail where you're at now until you sit there until the court could process you. You understand that?
Yes, I do.
All right. The paperwork will get processed today in the court system as quickly as we can, and we'll get it over to the jail so that you'll be released today. But it'll take a little bit to do that, but we'll work at it as quickly as we can and get it over there so that you can get out. But you need to show up every time you're supposed to be in court.
Okay.
Ms. Poplin, here's what I'm going to do so that you know about it ahead of time.
Okay.
There's going to be what's called a pretrial conference. That's between your lawyer and the prosecutor. They're going to try to resolve the case, and that's going to be on June the 24th. That's a Wednesday. Prosecutor typically does his pretrials on that date. Basically, your attorney will call the prosecutor on that date. I want you to talk to your attorney shortly thereafter so that you know what's going on, what the attorneys have talked about. And then you're going to have a hearing. You're going to have a Zoom hearing with me on July 2nd at 9 a.m. So you're going to be required to call in on the Zoom and you'll get the paperwork from the court sent to that Trillium Trail address for you to appear via Zoom on July the 2nd at 9 a.m. But I'm telling you now so that you know ahead of time, so there's no excuse for you not showing up, okay?
Okay.
All right. So you'll be released later today. Make sure that you find out who your attorney is, who's being appointed for you. Have contact with him after that June 24th hearing, and then I'll see you again on July 2nd at 9 a.m. All right, ma'am?
Okay. All right, sir.
All right. That's all for today then. Thank you very much.
Thank you, Your Honor.
Thank you. State of Michigan versus Casey Haas, file 25-43708-SM, set for status conference.
Yes, James Dick on behalf of Ms. Haas, who is appearing via Zoom, Your Honor.
All right, I do see Ms. Haas is with us. Do we have a resolution of this matter, Mr. Dick?
Yes, Your Honor. Ms. Haas will be pleading guilty to an added count to retail fraud, third degree, in exchange for dismissal of the original count.
Mr. Fortier, is that accurate?
Sure. Yes.
All right. Ms. Haas, you've heard what the lawyers have said. Is that what you want to do?
Yes.
All right. If you want to do that, you'd be giving up your right to have a trial and all of the proceedings that would happen at a trial. Do you understand that?
Yes.
Let me detail those things for you so that you can make an informed decision. At a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to have Mr. Dick, your attorney, represent you at that trial. At the trial, you could see, hear, and question the witnesses against you. You could get a subpoena to require your witnesses to appear and testify. You could choose to testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error, but if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes.
Do you have a question about any of those rights?
No.
Knowing all of that, do you still wish to enter your plea today?
Yes.
I need to take some testimony from you then, so would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, go ahead and put your hand down. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right, the reduced charge of retail fraud in the third degree would read as follows. It would say that on or about December 25th of 2024 in the city of Gaylord and Otsego County, that you did commit the offense of retail fraud third degree in that while Chalet Marathon was open to the public, you did steal property at the store that was offered for sale at a price of less than $200. Is that what happened?
Yes.
When did you go into, about what time was it when you went into the Chalet Marathon?
It was shortly after midnight on Christmas Day. I was out Christmas shopping and I was out of money and my phone had died and I had taken a phone charger to charge my phone because I was trying to get a hold of my babysitter.
All right. So what is it that you took from the Chalet Marathon? Was it the phone chargers?
Yeah, it was a phone charger.
And that was an item that was offered for sale at the marathon station?
Yes.
All right. And you knew that by taking it, you were not paying for it and that you were stealing. Is that correct?
That's correct.
All right. Either counsel have any additional factual basis questions?
No, Your Honor.
I'm sorry, Mr. Fortier. Mr. Fortier, are you aware of any other promises, threats, or inducements not stated on the record?
No.
I'm sorry, Mr. Dick as well. Anything about that?
No, Your Honor. Thank you.
Do both counsel believe that I've complied with the court rule?
You have.
Yes, Your Honor.
All right. I will accept the plea. I believe Ms. Haas has given me a proper factual basis indicating she went into the Chalet Marathon on Christmas Day, took a phone charger that was offered for sale and stole it because she lacked money at the time and her phone was dying. I believe she's given me that plea knowingly, intelligently, and voluntarily based on the answers to my questions, so I will accept the plea. Mr. Fortier, do we need to wait for a victim statement in this matter?
No, Your Honor.
Mr. Dick, would you like to proceed directly to sentencing?
Yes, Your Honor.
All right, Ms. Haas, I'm going to listen to both of the lawyers make their recommendations as to what they think I should do for sentencing. Once
Okay.
you've heard all of that, I'm going to give you an opportunity to tell me anything else that you want me to know before I decide what to do. Mr. Fortier, your thoughts?
So, Judge, there is restitution in this matter that we are seeking. It's $139.98. She does have a prior retail fraud third degree conviction from 2022. So I do think in this case, the court should consider a short period of probation. One of the things that I would like to see if the court does that is that she take the economic crimes class, especially with this being a second retail fraud. I think it would be appropriate for that class to be ordered so that she can, kind of learn that, stealing items has more of an effect on individuals than, just the store being out something. So aside from that, just the restitution, I think probation with the economic crimes class would be appropriate. And I'm not going to ask for any jail in this case, even though it is a second offense within just the last couple of years, but I would leave the issue of, community service up to the court.
Thank you. Mr. Dick, your allocution?
Yes, Judge. I do want to start with the police report does reflect that all items were recovered. I don't know if Mr. Fortier noticed that. It was on page 4 of the police report.
They weren't able to restock the.
Oh, okay. Understood.
Yeah.
Well, all right. With that being said, Your Honor, as Mr. Fortier mentioned, Ms. Haas does not have an extensive criminal history. The unfortunate circumstances of poverty sometimes leads people to make irrational decisions. Here, Ms. Haas, as she provided the court already, she had a phone that was dead. She needed to get in touch with her babysitter to talk about her kids or to reach out about her kids. She had no money left. She does realize that she probably should have perhaps asked to use a charger rather than take one, but it was an impulsive decision at the time, and she does take ownership of it, Your Honor. With that being said, I think that Mr. Fortier's proposal to the court seems to be fair and reasonable under the circumstances.
Thank you. Ms. Haas, is there anything that you want to tell me?
No, other than I just apologize that I'm in front of you today for something so petty. It should have never happened.
How old are your children?
I have a 12-year-old, a 9-year-old, an 8-year-old, a 7-year-old, and a 5-year-old.
Your 12-year-old goes into the Chalet Marathon and takes a phone charger. What are you going to do?
I would make him return it.
And
And I would probably scold him for it.
what if he did it 3 months ago and then did it again?
I would say I'd probably take his phone away.
You understand what I'm talking to you about, right? This is not the first time that you've done this.
Right. I understand that.
So what do I need to take away from you?
I guess
Well, you told me you take away your son's phone, right? So what do I need to take away from you?
I guess I don't understand what you're, I mean, I gave the items back.
You told me the second time that your son stole from Chalet Marathon that you would take away his phone as a punishment.
Right.
Now you're the son, I'm the parent. What do I take away from you to get you to not do this anymore?
I don't know. I guess I'm confused.
Still waiting?
Hope I'm in the right room.
This is not a
I guess
difficult
it-
concept, Saz. You got to learn from your mistakes.
Right, I
Something
understand
needs
that,
to be
and
done.
that's why I would be willing to do like probation and not going back in there, or community service, or like the situation I was in, I wasn't like, I don't know. Ultimately, it's up to you.
You're right, it is, but my job is to try to make it that you don't do this again.
Right,
So
it's not going to happen again.
Well, I'm sure that you said that the first time it happened. Here we are 3 years later. At some point, it's no longer a mistake. One time is a mistake, 2 times begins to be a pattern of behavior.
Right, I understand that. I apologize.
How long have you lived in Gaylord?
My whole life.
I've been here for about 30 some years, and I've found this place to be one of the more giving places that I've ever lived. That is, if you need something, people will literally give you the shirt off their back if that's what you need. If you ask for something, they would be more than happy to give it to you. You don't need to steal. This is one of the last places in the world that you need to steal from.
Right.
So let's stop it. Because next time you are going to jail, there isn't any doubt in my mind. I'm already thinking about whether or not I need to send you to jail. So there's no doubt in my mind, if you do this again, you're going to jail. You understand me?
Yes.
All right. You're going to be on probation for 6 months. It's going to cost you $180 in probation oversight fees. There's a crime victim fee of $75, a justice assessment of $50. There's restitution of $139.98. Court costs of $150, a fine of $75, and a local fee of $15. Let me add all that up for you. $684.98. The most expensive phone charger you will ever find. You pay that over probation. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation officer. You must enroll in and successfully complete the economic crime class. Do you work, ma'am?
No, I do not.
Are you physically able to do physical labor?
Yeah. I'm at home because one of my children is autistic, so I'm a stay-at-home mom.
You have somebody that you use on a regular basis as a babysitter? Daycare?
No, not entirely. Like my mom babysits for me sometimes, but her health isn't the greatest.
You have
So
siblings?
she babysits like in emergency situations, but other than that, I'm kind of on my own.
Do you have siblings?
I do, but we're not in speaking terms.
Well, you're gonna need to find somebody because you're gonna do some work camp days. 3 days work camp within the next 30 days. I'll let you schedule that as you need to, but they will be done within 30 days. No entrance into Chalet Marathon. I'm going to give you the phone number for probation. You're going to need to contact them to make sure that you are properly registered and know what you need to do for probation. Good luck to you, ma'am.
Thank you.
Court calls case versus Tamika Schlip.
Morning, Your Honor. Asked to Delta for the people.
Schlip?
Morning, Your Honor.
Wow.
Bright and early on your docket today.
No, go ahead.
Christina Costantino appearing with and on behalf of Tamika Schlip, who is present via Zoom from the Michigan Department of Corrections. Tamika, once you're unmuted, can you state your name for the judge?
Hi, Mr. Simpson. It's me, Tamika Schlip.
Hello, Miss Schlip. How are you?
I'm doing okay. I got my parole, but it's on hold until I get done with this case. Then I'm going to challenge the psychiatric hospital.
Ah, okay.
Judge, on the bright side, I'm told.
Oh, it's having her back.
I'm told it's her birthday today on the bright side. So, you know.
Yeah, today's my birthday. I'm 36.
Oh, you can't be that old.
I'm 36.
30. Okay. All right.
I have a son. My son's 11 and my daughter's 10. I'm an old person.
Okay. All right.
Judge, I was just appointed to Ms. Schlip's matter last night, so I need to get discovery and need to meet with her to discuss the matter. So we would be asking for an adjournment of the PCC.
We were going to ask for the 2 weeks, please, Your Honor, since I understand this may be holding up her parole.
This may be holding. Oh, you're right.
That's my understanding. Yes, Judge.
My parole's on hold until this case is gone.
Got it.
I really want to go home.
Yes, ma'am. All right. June 25th.
When?
2026, 9 a.m. So we put it out to the 25th, Miss Slip.
Okay, at what time?
Well, I said it at 9 a.m. We'll see about that time, okay?
Okay, and Mr. Simpson, I just want to let you know I've been praying for you.
Thank you, Miss Slip. Appreciate it. Happy birthday.
Thank you to me.
Judge.
Court does call the case. People versus Devin, Julia Martinez.
Yes, Stephanie Cannon on behalf of.
Oh, you're back. I mean, hi.
Here. Your Honor, we're going to waive our right to preliminary exam. I did not know they were not going to bring her. So the paperwork as far as that. Yeah, Ms. Martinez, can I sign the waiver with your permission so we can waive over to circuit court?
Yes.
All right. And Ms. Martinez, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct. I would like to also adjust my bond to being released to treatment, please.
Well, let's get the waiver done. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 in the case ending in 5840 and on counts 1 and 2 in the other matter with 3 and 4 problem.
Your Honor, as to bond, as my client has indicated, we are requesting that she be released on bond. I would ask for a very, very low monetary bond with a release to treatment. The reason for that is I do believe the cases she already has in circuit court, Judge Mood has denied bond. So in order for her to get credit for this case while she's there, a low.
Denied bond, and you want me to give her a bond?
Your Honor, I'm going to try to give some mitigation information the next time we are up before Judge Mood so that we can get bond in that court as well.
That was also to address bond.
Good. Yeah.
So
done with your argument, or?
Well, Your Honor, I see the look on your face, but
what does that mean?
Ms. Martinez would like.
Look. What does that mean?
It looks.
What? It's
the look of understanding that you.
Oh, okay.
Now, Ms. Martinez would like the court to know that the reason why she didn't wind up in treatment the last time is because when she got there, they said some information was incorrect, therefore she could not go, and they denied her access to treatment. She wants the court to know that that information will be corrected.
Which time was that?
The last time, Your Honor.
Happened a couple times.
I understand.
That
Your Honor.
has never happened before. That's never happened before. They denied me because it was some information.
She wants you to know that she does have a job. She has stable housing. She has a support system in the community. She's very remorseful regarding what happened. She's ready for this to be over. Her mental health has stabilized a great deal. She wants the court to know that. She wants to just get this over with some treatment. And so she's asking that you allow her to be released onto other treatment.
People's response.
Your Honor, I'm going to be objecting. This is history of she also has been contacting the victim of the domestic violence charge from in custody after being arraigned. There are 20 complete calls. So at this time, I'm going to be asking for phone privileges to revoke, given that she is calling the victim, asking, what did you do that for? Blaming him for being in jail, bringing up the assault charges, knows she's not supposed to be contacting him, so she addresses that in the calls. She also has the failure to appear. That would give me concern that she will leave treatment or not come back to treatment, and she does have that hold out of the 22nd with bond denied. There's also another hold I saw on a 14A1 with bond denied.
Yes.
And a hold out of 15th for fraud second for $100 bond. So at this point, I have concerns about her attendance in court and also that she can't comply with bond conditions, given that she is violating her bond in custody at this point.
And again, Your Honor, my client understands the severity of her situation and circumstance, and she is very inclined to participate as in bond as the court would request at this point.
As to the circuit court arraignment.
Yes, Your Honor. She's been arraigned today.
Circuit court.
Oh, sorry, I got caught up in the bond thing. Yes, Your Honor. Your Honor, we will waive the reading of the. I know.
I know.
Waive the reading as to the information, Your Honor, and we would plead not guilty as to charges. I forgot we waived.
Defendant having waived formal reading, pleading not the court will enter that plea. Pre-trial in these matters will be set for June 22nd, 2026, 1:30 with Judge Hamoud. In the possession case, motion for bond reduction is denied. Bond will continue as set in that case. In the other matter, the motion, defendant's motion for bond reduction is denied. People's motion to restrict or revoke her phone privileges and texting is granted. Her motion to reduce the monetary amount of her bond is denied. And quite frankly, given the circumstances, I was going to revoke it, but I'll just deny it at this time because Judge Hamoud has a handle on it.
Can I speak to my lawyer, please?
Devin, I will try to see
you
later
available
if possible.
All right, thank you.
What did you say? What did she say?
She said she will be down to see you as soon as she's available.
Okay.
Kind of. That's what I heard. Yes, let me get these to hand because I got. Yeah, no. Yeah, let's get them to hand and then. Court calls case People versus DeJure Bond Sanders.
Yeah, present on behalf of the people, Your Honor.
Good morning, Your Honor. Ashley Hannibal for Mr. Bond Sanders requesting permission to practice pursuant to Michigan Court Rule 8.120.
Leave her alone. What?
Okay.
You guys are doing just fine. Hey, watch the upgrade on.
No, that was useful. I didn't know for adjourning today. That's not why I had.
You know what?
We'd like to request an adjournment.
That's not your fault. You know whose fault it is?
No.
All right. Permission to practices.
All right, thank you.
Go ahead. Did you state your offense?
I did, Your Honor.
Okay.
I went for.
You want more? Got it.
I think why we're adjourning today.
Pardon?
I think is why we're adjourning today.
Gotcha. Okay. What are the bond issues?
Your Honor, it came to my attention that Mr. Von Sanders has been contacting the victims since he's been arraigned. There are 39 calls from his PIN to turn over. So this time I'm going to be asking that his phone and text privileges be revoked. I did also want to note for the court that I've received media from the other agencies that assisted on this case yesterday, and that could potentially be leading to more charges, including resisting and obstructing and potentially felony firearm. Which also is part of the reason for the adjournment as well.
All right. You have any response to that? No.
I don't.
I'm just gonna step in on that one, Your Honor.
That's fine.
Thank you. Your Honor, I did talk to my client yesterday. He indicated to me when he was arrested, he was under the influence of alcohol. He was arraigned and he kept telling them, he's like, I don't understand what's happening. I don't understand what's happening. It's my understanding that so when they took him up, he was telling them, he's like, I'm not right. But they arraigned him anyway. Okay. And I explained to him that at that point, the court would have told you that you can't have contact with the complaining witness in this case. And he said, I don't recall that. I don't remember anyone telling me I can't have contact. Again, Your Honor, he was highly inebriated at the time of this, according to my client. And also he thought that the person they were indicating, he's like, at the end of this, based on the conversations he had, he thought the complaining witness was his cousin. And so he didn't know that that he couldn't be in contact with at least two of the individuals that they're saying he was having contact with. And I don't know that the court order actually said he couldn't have contact with the child.
Your Honor, I will note one of the calls. He does mention his no contact list of the people he's not allowed to contact. And in that, he mentions the victim, the victim's mom, and the kids.
So he actually says it.
In the call.
Really?
And Mr. Von Sanders has been before this court before on.
I was gonna say that, but he specifically listed out those things.
Called to the victim. Defendant mentions who he has on his no contact list. His no contact list consists of the victim, the victim's mother, the kids, and some other people he claims not to know.
And then after that, he makes contact. Oh, okay. So despite being highly inebriated, not understanding what the magistrate was saying, seems to know enough to communicate it to other people.
No, I didn't.
Wow.
My client is
So your client and what you represented to the court, and I'm not blaming counsel because you only go based on what he says, also represented something that appears to be a falsehood.
Your Honor, my client is still, he's denying that happened. I don't have those phone calls.
Denying the phone call happened?
He's denying that he said that he knew who he couldn't contact.
Thought it was Kenya Davis, the only person that I knew of. I didn't know about anybody else that was on my case. Like I told them I was under the influence. I had been drinking like 3, 4, 5 that day. I didn't know that my victim on my case was my case. I mean, I'm just saying though, y'all not giving me the option to talk. I have the right to talk, right or wrong. No?
Go ahead.
I didn't know what.
You know what? You got counsel, but if you want to take a shot, take a shot. You can talk to me.
Your Honor,
talk to anybody.
We're asking that those calls be turned over to our office for review with the client. And we are denying the accusations.
At this time?
Yes.
Understood. All right. And I'm sure those calls will get over to them today. All right. Anything else regarding this?
Your Honor, we are also requesting the 911 tape in this matter, which
on the 10th. So normally they'll get those on by Friday or Monday.
Probable cause conference will be adjourned to June 25th, 2026, 9 a.m. Bond at this time, given the people's motion, his bond is revoked. It's also his phone and texting privileges are hereby revoked also. Thank you.
Thank you, Your Honor.
So, thank you.
Have a good day.
Court does other people versus Cora Thomason.
That's spelled with people.
Good afternoon, Your Honor. Trovius Star on behalf of Ms. Thomason. Thomason, state your name, please.
Cora Thomason.
Thank you.
We have a plea resolution here.
To take a plea with gum in her mouth.
Trash can right there. Okay, go ahead.
Sorry, Your Honor.
The felony MDOP of police or fire property will be reduced to malicious destruction of property.
Oh, hold on. No, her plea is that she's going to plead to added counts 3 and 4. Count 3 being malicious destruction of property 200 to 1,000, the 1-year offense, and an added count of operating while visibly impaired, a 93-day offense. Upon her successful plea, 2 counts 3 and 4, counts 1 and 2 would dismiss. There is also an agreement that defendant agrees to make restitution to the state of Michigan at an estimated amount of $4,600. And that's the court's full understanding of it.
That is correct. I complete recitation of the hearing.
That is correct. The restitution amount is estimated, but it's not confirmed just yet. Right.
That's what the police, the trooper put in his report as the value of the damaged property.
All right. Okay, I have her sworn.
Right. Felon sworn to affirm the testimony you're about to give me the truth, the whole truth, and nothing but the truth so help you God.
Yes, sir.
State your name, please.
Cora Thomason.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
First would be an added count 3, malicious destruction of property 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property injured or otherwise damaged. If that's greater than $2,000, that amount becomes your maximum fine. You understand that?
Yes.
Also, that you'll be pleading guilty to an added count 4 of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Could also order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
All right. Still wish to plead guilty? Yes?
Yes, sir.
To the charge of malicious destruction of property 200 to 1,000, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of these offenses?
Yes, sir.
On the date of January 30th, 2026, at the location of Tuttle Hill Road near Willow Road in Augusta Township, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
You recall what you had and how much?
Yes, I had about 2 drinks. It was
Probably about 2 hours before I was
2 drinks of what?
liquor.
Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I hit a patch of ice and hit a snowbank.
Okay, so your vehicle went into a snowbank?
Yes, sir.
All right. And then did the police arrive?
Yes, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital?
Yes, Your Honor.
Was there a blood draw?
Yes, sir.
And what were the results of that blood draw?
Like a 0.1.
I'm not 100% sure, Your Honor.
Trying to pull it up, Your Honor, sir.
It's okay.
Yeah, Your Honor. Well, the blood draw indicates 0.168. Which people would think is almost certainly more than 2 drinks, and also 11 nanograms of active THC.
All right.
Your Honor, may I respond to that one?
I'll need to respond.
Okay.
Your Honor, we do stipulate to the blood.
All right. So you have, ma'am, you have no objection to those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle is visibly impaired due to your consumption of alcohol and THC?
Yes, Your Honor.
All right. And then what happened between you and the Michigan State Police computer?
I kicked it.
Where were you when you did that?
I was in the front seat.
They put you in the front seat of the patrol car, and then you kicked the computer that was there that the officer uses?
Yes, Your Honor.
Okay. Probably because everybody wants to know. Why'd you do that?
I had a momentary lapse of emotional regulation. I was just slightly upset. I was distraught. The fact that I was in the ditch already, and I had been sitting out there in the cold, and the officer was not very kind to me. So.
He wasn't very kind to you?
No.
What does that mean?
I had asked him for clarification on how he wanted me to perform something, and he refused to give me clarification and proceeded to arrest me and put me in the cop car.
To grasp or harass you?
No, he didn't harass me. He didn't want to give me any clarification, so he arrested me.
No.
Not my brightest moment.
Arrested you because you were drunk and operating a motor vehicle. He didn't arrest you because you asked for clarification.
Yes, Your Honor.
You're on that, right?
Yes, sir.
Ma'am, I do have to apprise you. Well, do you agree that I should do this, when you kick the computer that you damaged it?
I'm sorry. Was I a what?
When you kicked the computer.
Yes.
That was in his vehicle and fundamentally attached to it, correct?
Yes, sir.
Did you damage that computer?
Yes.
Would you agree that the damage would be approximately about $4,600?
I'm not sure, Your Honor.
Okay, let's try this. You would agree that the damage to that computer is in excess of 1,000?
Yes, Your Honor. I imagine so, yes.
Pardon?
I imagine so, yes. So,
Really, Rush?
Yeah, think you better.
Your Honor, to answer your question at the bench conference, if she tested today, what will be in the system? She informed me that marijuana will be in the system. She has a medical marijuana card. So she informed me that will be in her system and nothing else.
That's the only thing?
yes, sir.
Because I have some concerns because I don't think one kick to the computer would have damaged it. And I think you're underestimating what you did that day.
May I speak, Your Honor?
What?
May I say something?
Sure.
I made a horrible decision, right? And I called her multiple times. I also, after sitting with that whole experience, I did call Officer Ryan and apologize to him because the situation was completely out of character. And I basically threw a temper tantrum like a little child. And there hasn't been one day that I haven't felt like just completely immature for what I did that night.
Including telling the story to a judge, because I think the way you were telling it to me was very immature.
I agree.
You will, that's the only thing that's going to show up in a drug test?
Yes, Your Honor.
You sure?
Absolutely.
Get over there, take a drug test. I'll call this case up later. Do they know that they're on their way? Okay. Just line them up. Court recalls case People versus Court Thomason.
Gosh, all this with people.
Afternoon, Provia Star on behalf of Ms. Thomason. Ms. Thomason.
Cora Thomason.
All right. That did just come back with THC. You have a medical marijuana card in there?
Yes, Your Honor.
All right. I don't know where was I on that? Please.
That was a little earlier. I have to go back.
Well,
We were on the factual basis for the admin count.
the
Malicious destruction of property.
correct.
We had a factual basis one day.
And I think she came back up and said it did repeatedly. Correct.
Yes, Your Honor.
And then the amount of damage that was done was in excess, and I think Mr. Starr, you were right, in excess of $200.
Yes, Your Honor.
That,
Yes, Your Honor.
all right. And I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. And secondly, that the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Far satisfied.
Satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is due ordered at 14A2 probation. Sentencing will be
July 7th at 10 a.m.
July 7th, 2026, 10 a.m. That is before Judge Barr. I will at this time continue the defendant's bond. Ma'am, I'm going to give you a suggestion and a bit of advice. I'd suggest that when you go over there and talk to his probation department, that you not minimize your behavior or attempt to give some excuse for it, because knowing my good friend Judge Barr, you do that, you're going to find yourself in the jail. Understood?
Yes, Your Honor. Thank you.
Thank you.
Thank you.
Bond continue. Court does call the case. People versus Amanda James.
Assistant Public Defender W. Leba on behalf of Ms. James.
Yes, sir.
Ms. James, can you tell the judge your name, please?
James.
Counsel approach, please. Or what council approach? I will pass it momentarily, but record to reflect the bench conference in this case. I shared with council some information that, ma'am, you've been using cocaine within the past day or so.
No,
Oh, so if
no,
I
it wasn't.
refer a test, are you gonna really come back clean?
Yes, I am.
Really?
I am.
Why'd you admit to certain people over at another court that that's what you did?
I called my probation.
I'll tell you what, before you lie to me.
I'm not gonna lie,
Oh,
Your Honor.
before you lie to me, because you already have started,
I'm not lying.
why don't we put her over there? We'll let Mr. Lebo talk to her and see if she really wants to maintain. Court recalls the case, People versus Amanda James.
Ready to go to the Your Honor?
Assistant Public Defender Duffy, leave on behalf of Ms. James. Ms. James, could you tell the judge your name again, please?
Amanda J.
And Your Honor, I believe Ms. James is now prepared to make a statement to the court.
She is. Okay, go ahead.
Yes, I did use 4 days ago. And when I was placed on probation yesterday, I was being honest with my probation officer and informed her that if this test does come back positive, it would be the only one.
So if you test today, you're gonna be clean.
I am honestly hoping that it's out of my system.
Well, we all can have hope. If you test today, are you going to be clean? See, you're already on thin.
Not gonna.
Hang on.
I'm gonna say no.
You're already on thin ice with me because you were about to lie. You were trying to lie to me. And so I'm gonna ask you again. If you test today, are you going to be clean?
I don't think so.
You don't think so?
I think there will be traces.
Okay, so now you said it, but I want to make sure. When was the last time you used?
4 days ago.
4 days ago.
4 days ago.
All right. Tell you what, let's get it. We'll send you over. Get a test. I'll pass it. Got to go over to community record. Get a test.
Thank you. Your Honor.
Okay, thank you.
Do you know where to go?
Yeah.
Okay.
And if she doesn't come back, it's a bench warrant, no bond, but go ahead. All right, let's see, who's next? It's this thing. Let's see right here. Court calls the case People versus Amanda James, recall. Or was no, I didn't want this one. Never mind. She went over there. Why are you handing me? Who is? Court recalls the case People versus Amanda James.
This is Public Defender Duffy, leave.
Client here.
She does not appear to be here, Your Honor. I did place a call, but I did not get an answer.
You lost her?
Looks like.
And she did not test.
Your Honor, I received confirmation she did not check in.
It's unfortunate.
I guess if she was gonna party before she thought she was going to jail, she might want to just keep partying because we're gonna get her.
All right.
Bench warrant will issue for defendant's failure to appear at this, and my file will reflect the defendant was test, did not go and did not come back. No bond.
Thank you, Your Honor.
What a day. Court does call the case. People versus Daniel Keener.
Daniel Keener.
And then on behalf of the people, Your Honor.
Assistant Public Defender Duffy, leave on behalf of Mr. Keener.
Mr. Keener, I need a camera.
Oh, I'm sorry.
State your name.
Daniel Keener.
And we're going to be requesting an adjournment in this case in order to receive some outstanding discovery.
Of your jail calls. Came to my attention, he called the victim one complete call after being arraigned, in which he was asking her to get some things in order for some keys, dropping things off, and then he called a different person and asked them to get in contact with the victim as well. exchange. I have concerns, given that he had the one complete call, one that was not completely accurate, but he has two pending domestic violence cases on his victim. One in 14B, they're both arraigned at the same time. One in 14B for a DV, and then one here before your honor for felony DV. So I have concerns that he was contacting her after he was being told not to contact her, and that he has two pending domestic violence related cases with her at this moment.
And Your Honor, I did have a chance to discuss it with Mr. Keener. Mr. Keener is not going to deny making those calls.
So why is he violating bond?
What Mr. Keener explained to me is that he had a misunderstanding of his bond conditions. I'm not entirely sure how he has.
Not contact her.
I'm not. I
How
haven't.
do we know, what confusion did he have?
I believe that what Mr. Keener experienced was that he was explained to that he could pick his things up as a civil standby, and for whatever reason, he believed he could call the complaining witness to coordinate that. I did discuss this with him in detail.
What?
Stands that absolutely no conversation is permitted.
He thought he had to, you know what? Where are you right now?
I'm in Detroit, sir. I
Pardon?
didn't. I'm in Detroit, sir. I was trying to get my keys.
Okay, well, that's about 45 minutes. We'll still be here. I want him here, and I want him to tell me that to my face.
Yes, sir.
So I'll pass your case. Don't appear by 4 o'clock. I'm issuing a bench warrant.
Yes, sir.
Thank you. What? What's the hoop for? I am perfectly calm. Joe, I really am. I really am. And I'm looking so forward to you coming up to that podium.
Court calls the case, recalls case, People versus Daniel Keener.
Assistant Public Defender Davy Lebo for Mr. Keener. Mr. Keener, could you tell the judge your name?
Daniel Keener.
And I did discuss the short system, Your Honor.
I came straight here.
What is it?
I came straight here.
Okay.
And I did discuss bond violation for this Mr. Keener. Mr. Keener would like to provide an explanation. Is that correct, Mr. Keener?
Yes.
And
so when I got arrested, I basically was just worried about my work uniforms and how to get my car. So I did make the call, and that was a mistake on my behalf. I shouldn't have done that, and I do realize that. Again, it was simply just to get my work uniforms in my car, and that was done. I haven't made contact. I haven't been in the area.
Well, why did you have to make it twice, or at least twice?
Huh?
He's talking about your call to your cousin.
That was only one call.
Your Honor, one call directly from Mr. Keener from his kid.
That's
Us to get a hold of the family mentioning her by name.
Yeah.
I didn't tell them to call her. They didn't have her number. She has my cousin's girlfriend's number and reached out.
What?
I didn't call my cousin to reach out to her. Like they already.
So why did they do that?
She reached out to him. She reached out to him to give him my keys so that he can grab my stuff.
Anything else?
I would just note that I think Mr. Keener understands. I had a long conversation with him. I think he understands the seriousness of the no contact order. I think he understands that he made a very severe mistake by violating it. And I think he understands that if he's fortunate enough to leave the court today, that this will be his last opportunity.
So you have one call, one direct call and one indirect?
Correct, Your Honor. And in the indirect, it says, I guess if you could tell the victim's name to call it to my job and let them know I won't be there again. So he's calling them to have them get in contact with her so she can contact his job, and he's not supposed to be having contact with her because he has two domestic violence cases pending with her as the victim.
Mr. Allen. Why are you doing that? Because that's not even
close to what you just told me before the prosecutor said what was said.
Calls that were made, one to her, one to my cousin. He doesn't have the information. It's just, can you call up to the job and let him know I wouldn't be there? I made
That's what you told me the first time.
I guess I didn't recall saying call up to my job for her to do that, but I did request for somebody to call up to my job. I was just panicking. I was just trying to get done what I could get done.
Your Honor, I would just note, all these communications were about his employment.
It what?
All these communications were about his employment. And I believe that that's what Mr. Keener was most concerned with at that time when he made these poor decisions.
But I thought there was this indication that about a civil standby.
Isn't that what you thought? You thought you could.
I reached out to Brian, who is my tether monitor person, but
This is the problem with the lie. Because you keep having to change your story.
No, it's the same story. It's the same thing. It's not a sorry.
Anything else?
No, Your Honor.
At this point, the defendant's bond. Well, first of all, with regard to his bond conditions, I'll grant the request there to be no phone calls or text privileges. But I don't think the defendant should have been contacting in any regard whatsoever. I will adjourn this out 1 week to June 18, 2026, 9 a.m. At this time, defendant's bond is revoked.
All right, we'll go on the record in State of Kansas versus Brady Smith, case number 24 CR 101. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant Brady Smith, that appears via Zoom from a separate location. Counsel.
All right, we're scheduled today for hearing on a warrant to show cause announcements. Mr. McClendon.
Your Honor, we would stipulate to the motion alleging the probation violations.
All right, Mr. Catley, you're also present here on this case.
Yes, Your Honor.
All right, Ed Catley from Community Corrections is present. Mr. Smith, you're admitting to these 3 violations that are set forth in the warrant to show cause?
Yes, Your Honor.
All right, those allege that you failed to report to Cali County Community Corrections for your intake appointment. Courtesy transfer was denied due to those lack of efforts, failing to make payments towards your case, and failing to enter Senate Bill 123 treatment. So you're admitting to each of those violations?
Yes, Your Honor.
Do you understand that you're entitled to have a hearing if you're contesting these allegations?
Yes, Your Honor.
And you understand at that hearing, the state would be required to put on evidence to show by a preponderance of the evidence that you did violate your probation?
Yes, Your Honor.
Do you understand that by admitting to these violations, I will make a finding that you violated your probation?
Yes, Your Honor.
Do you understand that you could be looking at doing a jail sanction, having your probation extended, or having your probation revoked and being ordered to serve your underlying sentence?
Yes, Your Honor.
All right. I do find these to be substantial violations. I will find that you're making a knowing and voluntary waiver of hearing and admitting to the violations, and we'll make the finding that your probation has been violated. Ms. Gillette, what are the state's recommendations for disposition?
Judge, this case is tough. Mr. Smith needs to understand that he has to report. He took off, and this is his second probation violation because he just didn't report to Cali County to get his transfer The last time we had a motion to revoke probation, he just took off and didn't make any contact, didn't report that he got arrested by the city of Mulvane on warrant, and had several requests from the Cali County Community Corrections to report to their agency to be a courtesy supervision. They sent it back and he did nothing for treatment. He was sentenced in January of 2025. And by May 21st of 2025, we had my motion on file, and Community Corrections had sent the revocation request May 19th of 2025. He was picked up on a warrant. He was sanctioned. He was given a chance, and he stipulated, and he needed to report to the jail by 5 p.m. and he needed to call his ISO immediately. Here we are again. In November, we already had the motion on file, and October 31st was when they said, hey, he's never come down here for his courtesy supervision. We're sending him back. Can't do anything. Nothing. He's been in jail. They gave him a furlough to go to Oklahoma, and he's currently sitting in Oklahoma outside of the state of Kansas to do treatment in Oklahoma. Well, I'm happy that he's in a treatment program. He's frankly done absolutely nothing on this case, and we're here on a second time. So I don't even know what to recommend, whether he should stay in treatment in Oklahoma and then come back when he's done, or if we should just revoke him outright since he's done absolutely nothing on this case. I don't even know if he's made contact with Mr. Ketley since he's gone to Oklahoma on a furlough. But frankly, he's basically flagrantly refused every orders of the court. Probation is a privilege, not a right. When you're on probation, is for you to get treatment the entire time, not run around continuing to use drugs, go to jail, and get a furlough from another jail to go to Oklahoma. Most individuals are supposed to be here in person in Kansas at our courthouse when we have a revocation hearing. He's already been sanctioned before. He needs a substantial sanction, or he needs his probation completely outright revoked.
Thank you, Ms. Gillette. Mr. Smith, looking at the docket notes, when you made a first appearance on this case, it looks like it was in front of Judge Webster. She ordered you to appear in person at the Greenwood County Courthouse. How come you're not at the Greenwood County Courthouse?
I had told her that I would be in treatment, and she just told me to get a hold of Mr. McClendon and talk to him about it. And I had called Mr. McClendon on as soon as I got out and was able to call him, and he just told me to be on Zoom.
Mr. McClendon, what are your recommendations?
Judge, first off, I do apologize for not clearing his permission to appear by Zoom with the court. I had an individual who he did not ask me to go to Oklahoma, so he was already in Oklahoma by the time. So I figured, if we have him in treatment already, I figured, hey, let's go ahead and have him appear by Zoom. I apologize for that. Judge, he's in a 90-day program. It's called Clay Crossings in Maud, Oklahoma. So far, he's done really well down there. He was reinstated on Senate Bill 123 out of his Cali County case, or is going to be, I believe, after he completes this stint for treatment here. So he did enter treatment on June 2nd. So 90 days from then, if I do my math right, it sounds like September 2nd would approximately be his release date. Judge, he knows he messed up, and he's trying to make himself better. He did go and he's working on sobriety here. I'd ask that he serve a sanction after he completes his 90 days and then be placed back on probation, Your Honor.
Thank you, Mr. McClendon. Mr. Ketley, has Mr. Smith done anything on his probation recently?
Not that I was aware of, Your Honor. And like the last case, I was unaware he is in any type of treatment program. I was not aware of that, especially in another state.
He hasn't remained in contact with you?
He has not.
Once he was denied transfer to Cali County, he hasn't contacted you?
No.
He also has a new case out of Wichita.
All right, Mr. Smith, is there anything that you'd like to say at this time?
If you could just give me one more shot on probation, I would be greatly appreciated. I'm trying to do everything that I can to get this right. Like I said, the whole reason of coming down here was to change my people, places, and things, and not be where I can run into old habits. And you know, I'm really trying this time, Your Honor.
Well, you're not trying very hard. You didn't even let Mr. Ketley know that you had been denied at Cali County. You didn't let him know that you were, or get permission to go to Oklahoma to do treatment, or let him know that you're in treatment. You haven't made any comments on your case.
Right. I thought that my attorney from Cali County had been in touch with Mr. Ed Ketley.
Well, apparently you thought wrong. How long have you been in Oklahoma?
Since June 2nd. I got released at 7 a.m. out of Cali County, and I was down here by 11. It's about a 3.5-hour drive.
The violations, the last time you were before me back in September of last year, were essentially the same that we're looking at today. You haven't done anything. I'm going to order that you serve a 60-day jail sanction. Where in Oklahoma are you?
Maud, Oklahoma.
Where's that?
Southeast of Oklahoma City.
You need to be in Eureka by 5 o'clock today to the Greenwood County Jail to serve your 60-day jail sanction.
So I don't get to complete treatment?
No.
Okay.
You haven't earned the right to complete treatment at this time by just completely blowing off probation, Mr. Smith. It's a little bit too late at this point. You can serve your jail sanction and then try it out again. But if you're not, go ahead.
I was just saying, how do I go about that with being on a furlough from Cali County?
You're going to have to figure that out. But if you're not the Greenwood County Jail by 5 o'clock today, then I'm going to order that the warrant be prepared.
Okay, Your Honor.
I'll waive attorney's fees for this round of hearings.
Judge, can we have an extension 12 months from today?
Is that necessary, Mr. Ketley?
Yes, Your Honor. He's due off next month.
All right. I will extend probation for 12 months from today's date. All right. Anything else?
No, Your Honor.
All right. We'll be in recess.
Judge, attorney's fees, bids fee.
I waive that.
Thank you.
All All right, we'll go on the record and State of Kansas versus Jordan Denny, case number 24 CR 26. Would counsel announce appearances, please?
May it please the court, the state appears by Jill Gillette County Attorney.
William McClendon for the defendant Jordan Denny, who appears via Zoom from a separate location, counsel.
All right, we are scheduled for hearing on a motion to revoke community corrections. Mr. McClendon, how does your client wish to proceed?
Your Honor, we would stipulate to the motion alleging the probation violations.
All right, is she also stipulating to the allegations in the addendum dated June 8?
I did not see the addendum, Your Honor. If I may review it.
All right, why don't you look at that? Mr. Catley, are you appearing for community corrections on this case?
Yes, I'm filling in for ISO Ashenfelter.
All right, Ed Catley from Community Corrections is also appearing.
Judge, if I could talk with my client briefly about the addendum.
All right, we're going to take a brief recess. Miss Denny, we're going to place you in a breakout room so you can visit privately with your attorney. All right, we're back on the record and State versus Denny, same appearances as before. Assuming Miss Gillette's on here. All right, Miss Denny, your screen's upside down or sideways. There we go. All right, Mr. McClendon, you've had an opportunity to visit with your client about the addendum. Is that correct?
Yes, Your Honor, it is. And we would stipulate such.
All right. Ms. Denny, do you understand that you're entitled to have a hearing if you're contesting these allegations? You'll need to unmute, please.
Yes, Your Honor.
All right, and you understand at that hearing, the state would be required to put on evidence to show by a preponderance of the evidence that you violated your probation as alleged? I wasn't able to hear that. Do you understand at that hearing, your attorney would be able to cross-examine the state's witnesses and you could put on evidence you felt was favorable to your position?
Yes, Your Honor.
Has anybody made any threats or promises to get you to waive your right to this hearing?
No, Your Honor.
Do you understand that by admitting these violations, I will find that you violated your probation?
Yes, Your Honor.
Do you understand that you could be looking at serving a jail sanction, having your probation extended, or having your probation outright revoked and being ordered to serve your underlying sentence?
Yes, Your Honor.
All right, Ms. Denny, I will find that you've made a knowing and voluntary waiver of hearing and admitted to the violations. I will find that you violated your probation. Ms. Gillette, what are the state's recommendations for disposition?
Judge, she had some sanctions that she voluntarily did. Her sanctions that she voluntarily did was a prior 2 days. Those days began on December 16th, 2025. Then she had a motion and a revocation filed May this year. She hasn't done her mental health. She has left her treatment and she just continues to not do the things that have to be done while on probation. She was unsuccessfully discharged from MRT. She hasn't done her drug and alcohol counseling. She hasn't reported any kind of employment full-time. And she's had positive samples for methamphetamine and fentanyl. And she failed to successfully complete Senate Bill 123. The reason you're on probation instead of going to jail is so that you can do your Senate Bill treatment, so you can participate in programs like MRT that give you the chance to change your life around. But you gotta want it. And we can't force them. They have to decide they want to do it. But she's gonna need a substantial sanction. I would ask normally for her to be outright revoked. She's done a voluntary sanction, but I don't think the court has sent her for a sanction. So I would request that she have a substantial sanction and then be extended on community corrections to do her treatment program. Again, treatment is a privilege, not a right. And Miss Denny's basically throwing it away. She's pregnant, she has a kid to look out for, and treatment is going to keep her from exposing her to-be-born infant to drugs that can cause permanent effects to babies. And it's
She's pregnant right now?
That's what it said in the motion to revoke, is that she was expecting. Her original motion said that on May 8th of 2026, she tested positive for a urine sample for methamphetamine and fentanyl, and it said she was currently pregnant at the time. So, you know, choices have consequences. I think she needs a sanction and then to be reinstated. And she'll probably need an extension 12 months from today.
All right, Mr. Catley, I know that you're just filling in for Miss Ashenfelter today, but she's been on probation since October of 2024.
Right, that's correct.
How come she's still on probation? She hasn't done anything?
I think treatment's been a huge issue for her, Your Honor, whether or not she goes.
And this was a Senate Bill 123 case.
Correct.
Has she done anything recently?
Not that I'm aware of, Your Honor, and I don't see any notes from ISO Ashenfelter about her being in treatment.
Okay, she hasn't made one payment on her case the whole time she's been on probation. All right, Mr. McClendon, what are your recommendations?
Well, Judge, Miss Denny stipulating today she was hoping that the court would have mercy and give her a sanction, preferably like a quick dip over the weekend. She did just get antibiotics for strep throat, so I think she's not contagious or is contagious for approximately another 24 hours. But otherwise, Judge, she'd be willing to do a sanction and be reinstated back on probation. She has several interviews lined up for sober living or treatment facilities. One of them particularly mirrors. She could get in as early as I think next week or possibly even tomorrow, but she needs her Saxeval and her Sassy to be sent over there to them so she's able to get in. Judge, she's only been out of custody approximately, looking back, bond was posted on the 3rd, so that's about 8 days, and that's including weekends, so not very long. And
how come she's not at the Greenwood County Courthouse? She was ordered to be at the Greenwood County Courthouse if she bonded out.
Judge, she called me this morning at approximately 9 o'clock and was saying she had car issues, and I figured a on time and on Zoom client would be better than a late and not here client. She was willing to drive that way, but I know I have obligations later today, and I wasn't able to sit around and wait on docket all day, Judge.
All right, thank you, Ms. McClendon, or Mr. McClendon. Ms. Denny, how come you're not at the courthouse as you were ordered to be?
I did just get out of the hospital this morning and I have my hospital paperwork. I can do that. One, I am 18 weeks. I also, I was trying to come down here. I was having car problems, even getting back from there. I had Uber back from the hospital, but I'm still able to come down there immediately if I need to be.
You're 18 weeks what?
Pregnant.
And you're using drugs?
I didn't know at the time, and no, that's why I'm trying to get into treatment as well. I'm not right now, but I also, if I would like to continue not using right now, and I just feel like treatment would be the best for me.
How come you're not in treatment right now then?
Because I left voicemails and emails to my corrections officer. I need them to send over my SASE and my SAC eval.
You've been on probation since October of 2024. How come you haven't completed treatment?
In December of 24, I had my son, and for the first, I didn't have help. Baby, my son's father is in prison, and I was by myself, completely by myself. I didn't have anyone to help me with my son, so it took me a while to even start really getting anything done because I had an infant child.
Where are you right now?
I'm at my house.
And where's that? What
505 North.
What town?
Wichita.
I'm going to order that you serve 60 days in the Greenwood County Jail. Starting today, you need to be at the Greenwood County Courthouse or the Greenwood County Jail by 3:00 p.m. and serve 60 days in jail. You haven't done anything, Miss Denny. You're pregnant. You're not in treatment. You're not clean. You've been on probation. Haven't done anything. So you need to spend some time in jail and think about whether or not you want to spend the first 30 months of your child's life in prison.
Yes, sir. I was trying to get into treatment this week, and I've been waiting, and I have
a little bit too late, Miss Denny.
I know. Absolutely, Your Honor. I was just trying this week to get in, and I haven't gotten a call back, and I've left multiple voicemails for my corrections officer to send over my SASE and my SAC eval.
All right. Well, you need to be at the Greenwood County Jail by 3:00 p.m. today. If you're not there, I would ask that a warrant be generated for her arrest.
Do I get any time credited that I was just in jail for, or no?
That'll go towards your 30 months, but you're doing 30 or 60 days from when
Yes,
you
Your
get
Honor.
checked in today.
Yes, Your Honor.
I'll waive any attorney's fees for this round of hearings. Does she need to be extended?
Yes.
I'll extend probation 12 months from today's date. When you get out of jail, you need to call your probation officer, Miss Denny.
Yes, Your Honor.
All right, counsel, anything else on Miss Denny's case?
No, Your Honor.
I think I'll get her jail credit awarded on the journal entry, Your Honor. She had from 5/28 to 6/3. So she had 6 days. And we'll make sure that's on there, plus the 3-day sanction she did for the ISO. Those dates are already wrote down so that we can have them.
All right. Miss Denny, serve your jail sanction, then get out, do your treatment. And I don't want to see you back here.
Yes, Your Honor.
All right. We'll be in recess.
That's all I have with you this morning, Judge Mandy.
All
Excuse.
right. Have a good day. Thank you.
Thank you, Judge.
I believe I am also finished, Your Honor.
All right. Thank you. Have a good day.
Court goes on the Zoom record. Case is entitled State of Kansas versus Kenneth Lee Idleton, 24 CR 16. State of Kansas appears by Assistant Butler County Attorney Brett Sweeney. The defendant, Mr. Idleton, appears in person, and by court-appointed counsel Jim Watts. Also appearing at this time is Court Service Officer Tony Bauer. This matter does regularly come back before the court this day for sentence. In anticipation of sentence, the court has ordered a pre-sentence investigation report. Court has received the same. I trust that counsel for the state and the defendant have received a copy. And before proceeding any further, is there any objection to the criminal history as set forth, which does indicate a criminal history score A as in Apple? Mr. Sweeney?
No objection, Your Honor.
And Mr. Watts?
No, Your Honor.
Court finds no objection to the criminal history, therefore it does become part of the basis for sentence herein. Prior to pronouncing judgment and sentence, the court will listen to recommendations from respective counsel as to appropriate sentence. And Mr. Sweeney.
Thank you. I would note this is presumptive prison, so presumably, Jim, did you file a departure motion in this?
I did. It was filed June 4.
Okay, and I would tell the court that pursuant to the plea agreement, the state is not objecting to that departure motion. So I'll go ahead and give my recommendations, and then I guess I'll let Jim make his departure arguments on the backside. But state's recommending 43 months in Department of Corrections, 15% good time, 24 months post-release supervision duration. He does have 126 days of jail time credit. If the court, there is a count 2. State is recommending 18 months in Department of Corrections on that count. Would ask that that count run concurrent to the primary count and count number 1. We would ask that this case run consecutive to any case that he was on supervision for probation, which looks to be 2 cases out of Craig County, Oklahoma, that are listed within the PSI. All of the probation conditions, if the court would adopt that recommendation, appear to be appropriate. State's not requesting a fine. We would, however, ask for court cost, all other standard costs and fees, and then, of course, attorney's fees if appropriate. That's all I have.
Thank you, Mr. Sweeney. And departure motion and recommendations as to sentence, Mr. Watts.
Thank you, Your Honor. As a departure motion, as an initial matter, one of the things we, of course, acknowledge that Mr. Idleton is an A on the grid. I think it's interesting to note why he's an A on the grid. And I was looking at the motion I filed, and it's something I usually deal with, and apparently I did not on this one. He has the person felonies who make him person felonies in this case are date back to 2014. There's a couple of assaults. That's the most recent. There is also 2014, and I note the PSI says this is a non-person felony flee and elude. That may well, in fact, should be a person felony flee and elude, given that the determination that whether or not it's a person felony is done by the state, and typically flee and eludes are person felonies. I don't know that it makes a big difference. He's an A on the grid either way, so it's not an issue. But I want to point out here that the cases that make him a person felony, with the exception of the registration case, in fact, even the registration case, are quite old. The argument in my case is somewhat different, however. One of the things I often talk about on cases where someone has entered a plea is that he's accepted responsibility, and he did in this case. This was never really about whether or not he registered or failed to register. If the court may remember the preliminary hearing in this case, the issue was over whether or not the state had documentation that he was ordered to register in the state of Oklahoma. Because in this case, his registration requirement, this is a registration violation case, his registration requirement is triggered entirely by his requirement to register in Oklahoma. So the issue was he ordered to register in Oklahoma? And my initial discovery did not include that document. Over the course of a preliminary hearing, that document became available. And once it was clear that document existed, that he had to register in Oklahoma, and I remember very well, leaned over to my client at that point and said, we don't need to go any further. They've already established what they have to establish, and there's no point in going any further. And at that point, we ended the preliminary hearing and waived preliminary hearing at that point. But I think it was within his right and frankly, my responsibility to make sure the state could actually prove up its case before we entered a waiver on that preliminary hearing. And once that was done, the waiver was entered. It was over at that point. So he did accept responsibility, but to be perfectly blunt, no defendant, either in this case or any other, should be expected to enter a plea or waive a preliminary hearing unless he's established that the state can in fact prove up what it is alleged. Any defendant would be foolish to do otherwise. And I think that's important here. So he has taken that responsibility. Again, it's never over whether or not he had to register, it's whether or not the state could prove that. The bigger issue is the particular offense that he has to register for. And Your Honor, I've argued a number of registration statutes cases, both before Your Honor and with other judges. It's an issue that I have raised again and again. And I understand that's an issue that generally doesn't have a lot of basis, to be perfectly blunt. That one of the statutory factors that's in the statute is that the degree of harm or loss is less than typical for the offense. And I have argued for years, and I still believe this is true. The registration statute is a paper felony. There is no harm or loss in a registration case. There is no victim. There is no person who's lost any property. There's no person that's lost any damages. There's no person that's been harmed at all. It is quite literally a paper felony. It is a felony for failure to file a piece of paper. However, that is true, and I would argue that's true in all registration cases. This registration case, that is most particularly true. And it's important because of the nature of the offense. The court may remember that in this case, he is required to register because he is a registration requirement in the state of Oklahoma. There is no Kansas offense that he requires him to register. He has to register because of Oklahoma offenses. The particular offense he has to register in Oklahoma, it's actually number 14 on the PSI. It's indecent exposure. That is the Oklahoma statute. That Oklahoma statute, and I looked it up in the elements on the Oklahoma website, and I believe I forwarded to the court the documents that spell out exactly what it was he did in Oklahoma. The Oklahoma statute requires exposure in a public place. That's it. The closest thing in Kansas would be a lewd and lascivious statute, but they are quite different statutes. In Kansas, lewd and lascivious requires an element of sexual gratification, and I'm absolutely certain of that, as I noted in the motion, because I tried a case before Judge Rickey on a bench trial on exactly that issue, as to whether or not lewd and lascivious and the state had proven up a sexual gratification element. In this case, down in Oklahoma, the crime was indecent exposure. And again, I forwarded to the court the charging documents and the police reports to support that. What my client did literally was Moonagard. There's no other way to put it. He was behind a window. He put his window up in his buttocks up in a window and Moonagard. That crime in Oklahoma is indecent exposure, and that crime in Oklahoma gets him on the registration list. Now, what's important to note about that? Let's assume that same act had occurred in Kansas. You're in the jail, you Moonagard. What crime has the prisoner committed? Well, we know that from the lewd and lascivious statute of the state of Kansas. And the answer is none. There is no crime for doing so. And that's because mooning a guard has no sexual component whatsoever. And as I noted in the motion, and I'll excuse the language on our hearing here today, but it is quite literally the expression of kiss my ass. That's what it is. It's not sexual in the least. Kansas statute requires a sexual gratification component. Now, I raise this because if there is ever a case where the underlying offense had little, if any, harm, we have here a underlying offense, the offense for which he must register, committed in Oklahoma, required in Kansas only because he has to register in Oklahoma, would not even be a crime in this state. There is no similar offense. So for those reasons, Your Honor, and I would note, and Mr. Sweeney had noted that, the state has graciously agreed to stand silent on this departure. My client's offenses are quite old, his person felony offenses. They're over a decade old now. This registration offense is one that replies that he acknowledged that he violated. He simply quit registering, and we acknowledge that. But it is for an offense that, had it happened in the state of Kansas, would not be a crime at all. It simply does not exist as a crime in the state. And so for all those reasons, Your Honor, we would request to grant departure. And while I'm thinking about it, Your Honor, and this may be quite late to do that, my client, and I've been sitting here waiting on this and I'd forgotten all about it. My client had requested that I consider a continuance in this matter before we argued this. And I apologize to my client that I'd forgotten about that until this moment.
Okay.
It took a while for us to get here. He is currently working. He has a job. He'd like to get his financial house in order before he faces the possibility of going to prison. I should have mentioned that before I got into the details of the departure, and I apologize for that. But my client would ask the court to consider that continuance, or in the alternative, to consider departing in this matter for the reasons previously noted.
Thank you, Mr. Watts. And Mr. Idleton.
Yes, sir.
Idleton, excuse me.
Yes, sir.
Prior to the court pronouncing judgment and sentence upon you, is there anything you would like to state in mitigation of your sentence?
Yes, sir. I was I was just young. I made a bad choice. I've grown from it. Right now, currently, I'm working at Coleman Company. It's the best I've ever done my whole life. If you could just give me a little bit of time to make sure that my girlfriend's rent and everything's taken care of, and I got a little bit of money to go handle my business, please.
Do you know of any reason why the court should not sentence you here today?
Yes, sir, because I'm really doing good right now, and like I want to strive for life, and I'm doing everything I'm supposed to do, and I'll show up on all my court dates. I just would really like the opportunity. I've only got one paycheck. I've only been working there 2 weeks. I've only got one paycheck, and I would like to make sure that me and my girlfriend's okay. And I'll just like to make sure my financial stuff is right.
Well, the question is, do you know of any reason why the court should not pass judgment and sentence upon you here today? Your sentence may very well be probation. It could, on the other hand, be prison. Do you have any objection to the court proceeding to sentence today?
Yes, sir. I'm just like I said, I'm not ready to. There's never a good time to go to jail, but I just got to get some things in line before I do go to jail. That way I'm comfortable.
The court is not advising you. The court may very well grant the departure motion herein.
Yes, sir. I understand that.
All right, Mr. Watts, do you want to consult with Mr. Idleton in regards to proceeding or not at this point?
I can, Your Honor. Thank you.
Court will order a breakout room with Mr. Idleton and Mr. Watts. All right, court is back on the record. The record may reflect the presence of all parties previously appearing in regards to 24 CR 16, Kenneth Lee Idleton. And Mr. Idleton, did you have an opportunity to speak with Mr. Watts in regards to your case about proceeding to sentence or not today?
Yes, sir. I talked to him, and there's no legal reason why I can't be sentenced today, Your Honor. I just would like to get my ducks in a row, but it's okay. I'm ready to move forward.
Court understands that to be a no. Is that correct?
Yes, sir.
Okay, thank you, Mr. Idleton. And Mr. Watts, do you know of any reason why the court should not pronounce judgment and sentence today in regards to Mr. Idleton?
I know no legal reason, Your Honor.
Thank you, Mr. Watts. Mr. Idleton, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control of the Secretary of Corrections, State of Kansas, to serve 43 months in prison as to count 1, failure to register pursuant to Kansas Registration Act. Court does order 15% good time credit, jail time credit of 126 days, post-release supervision period of 24 months. As to count 2, failure to register pursuant to the Kansas Registration Act, the court orders 18 months with the Secretary of Corrections, State of Kansas. The court is in receipt of your dispositional departure motion. The court finds that the state is remaining silent as to the departure motion, the dispositional departure motion. The court does adopt the arguments as set forth in that departure motion, and the court does place you on community corrections probation from this prison sentence. The court does place all standard probation conditions upon you, along with all standard probation conditions, and those probation conditions, costs, and fees as set forth on page 5 of the pre-sentence investigation report. And Mr. Idleton, you said you're currently employed, is that correct?
Yes, sir. I work at Coleman Company.
Okay. Approximately how much do you earn per month?
I haven't been there long enough for a month, but I make $17 an hour, and I work 5 days a week, so I get like $5.50 a week.
Okay. Well, it appears that you have the sufficient funds to reimburse for the state court-appointed attorney fees and bids application fee. So the court does order the same. Court does place you on community corrections probation for a period of 24 months. The court does order that you reimburse the state at the rate of $100 per month on your court-appointed attorney fees, bids application fee, any of your costs and fees as recommended and set forth on page 5 of the pre-sentence investigation report. The court does, excuse me, the court does sentence you, the court does sentence you to serve this sentence consecutive to your Oklahoma cases that are set forth in the pre-sentence investigation report. Court does advise you pursuant to KSA 223608C that you shall have 14 days after the judgment of the district court to appeal your sentence. Court advises you pursuant to KSA 214619G of any expungement rights you may have, and the court advises you of your prohibition of possession of any firearm. And Mr. Idleton, do you have any questions?
Yes, Your Honor. I'm paying DA supervision fines in Oklahoma. I'm paying probation fines in Oklahoma, restitution fines in Oklahoma, and it's every month. And I got rent, you know, the everyday living. I can't afford $100 a month. I'm just being honest with you.
What do you believe you can afford in your opinion?
I think $50 would be there shouldn't be no problems with me paying $50 every time, one time.
$50 per month?
Yeah, yeah, if that's possible.
Court orders that you pay $50 per month pursuant to your suggestion.
Thank you.
Yes, sir.
Thank you.
Anything further? Mr. Sweeney?
No, Your Honor.
Mr. Watts?
No, sir. Thank you.
And Ms. Ashenfelter?
No, Your Honor.
We'll put you in a breakout room with Ms. Ashenfelter in regards to the community corrections program.
Okay.
Mr. Idleton?
Yes, sir.
Good luck to you. I wish you well.
Thank you.
There being nothing further to come before the court, court is in recess. You're free to go after you talk with Ms. Ashenfelter.
All right, thank you.
Big win for Mr. Watts there. Wow. Keep calm and carry, ladies and gentlemen. It's actually not every day that you see James Watts come away with a little. It wasn't an absolute win, but it was definitely a win. Look at that dog laid out right there. Oh my goodness. I did not do anything to it. I swear. It was a crazy case, was it not? Putting somebody on a registry for mooning a prison guard. I mean, I understand you want to throw the book at them, but I mean, that registry is for some pretty important stuff that doesn't include just extra punishments for people that. Wow, Dob, thank you so much for the gift there. Oh, that's so cool. Did y'all see that pop up? That was neat. I like it. Anyway, I just don't know. I think that sounds weird to me. And the funny part I thought with that was like that was not even a crime in Kansas. Like if it had been done in Kansas, it wouldn't have. Everybody would just have laughed about it and like you. I seem to remember at some point in time a Supreme Court case revolving around a mooning situation. All of this is going very wrong very quickly. But I swear, I think I remember this, even though I might have hallucinated, I'm not sure. I swear I remember that somebody at some point in time at a Supreme Court level held that mooning someone was actually free speech. I could be wrong about that. I don't know. What I do know is I need to click this little start credits button and let these names roll. And I need to thank Julie, Specs, Kiernoth, and just call me Stephen Foffler. Is that correct? Is that all correct? There's a lot more people than that. Natasha, Kitty, Northwest, Living Like a Cat, Dobby, Rhonda, and Marty, Mary Beth, Nina, out of the blue, Eileen, Math Girl, all the rest of you. All you awesome people hanging out in chat, making chat the amazing place it is. Thank you so very much for hanging out. Thank you so much. We're going to do this again tomorrow. We'll find some more cases. We're all going to meet right back here. Same Wolf time, same Wolf channel. We'll have a lot of cases to review together. And Dave Reeves started things out with Hesselink. Right? Yeah. That one guy. How many times have we seen him in the last 2 weeks? A lot. Oh, man. I can't even. I'm trying to think back over all of the crazy stuff we saw tonight, and it's all just going, woo. Just like the meme. Woo. Have a marvelous Friday, ladies and gentlemen, and come back and hang out with us tomorrow night. And don't forget about the weekend review on Saturday. And Dobby's got that flow state chat. Thank you all so very much. Thank you, Felix, Matt, Hoffman Art. I got it right. Becky. Thank you, Becky. Thank you, Mama. Thank you, Living Like a Cat. Thank you, Math Girl. Thank you, everyone. I am your Lone Wolf Uso. And I am out. Oh, hi. Fancy seeing you here. I'm Lone Wolf Uso. I host these things from time to time when I don't have a claw being held to my throat by a crazy little feline furball that scares me every single day, and I just need help. Please. He wants more court. He just wants more court. That's all he wants. More court. Meow. Court. Meow. Court. Meow. Bye. Oh.